The relationship between morality and law has fascinated thinkers through the ages. Some have seen law as a guardian of moral order, while others have warned of the dangers in intertwining the two. In the 1960s, this debate came alive in the famous Hart-Devlin Exchange, a landmark discussion on whether the law should enforce moral standards. It marked a deep exploration of the fusion and confusion between legality and morality. The same decade saw the House of Lords in Shaw versus DPP observing that law had residual powers to enforce what is called its supreme and fundamental purpose to preserve not only public order and safety but also the moral welfare of the state. The Supreme Court of India in P. Rathinam versus Union of India reflected this relationship when it quoted the words of Justice Frankfurter from Solesby versus Malcolm. He wrote that law embodies a system of right based on moral principles, which comports with the deepest notions of what is fair, right, and just. Centuries earlier, in India's own philosophical tradition, there was no sharp boundary between law and morality. The unifying concept of dharma wove both together. The Thirukal, for instance, speaks at length about Aarambh, the virtue of righteousness that defines human conduct. This constant interplay shows that sometimes law leads morality, as with the abolition of untouchability, which legal reform pursued long before social acceptance. At other times, morality leads law, as in the gradual recognition of gender equality. The real challenge lies in ensuring laws remain rooted in justice and ethical imperatives beyond the reach of majoritarian modes of fleeting sentiments. In recent decades, a new wave of thoughts has revived this discussion under the banner of constitutional morality. What does this mean? Where does it draw its power? The term itself is not new. Historian George Grote first used it in his 1846 book History of Greece. He described constitutional morality as a citizen's profound reverence for the constitution's forms, obedience to lawful authority, freedom of speech and criticism, and the confidence that even political opponents would treat the constitution as sacred. During the Constituent Assembly debates, Dr. Bhim Rao Ambedkar drew from Grote's words. He argued for detailed constitutional arrangements and institutions that could uphold such morality. Ambedkar reminded the nation that constitutional morality is not a natural sentiment, it has to be cultivated. He famously warned that India's democracy was only a top dressing on an essentially undemocratic soil. What exactly is constitutional morality? It can be seen as the ethical code guiding constitutional functionaries, but here arises a key question. If someone violates these moral expectations, can courts intervene? To answer this, A.B. Dicey, the noted jurist, made an important distinction. He explained that constitutional law consists of two parts: the law of constitution, that is enforceable by courts. Second is convention of constitution, that is unwritten practices, understandings, and habits that guide conduct but are not legally binding. Dicey regarded these conventions as constitutional morality. While breaches may not invite judicial action, they carry political and moral consequences. This idea appeared in Indian jurisprudence too. In the S.P. Gupta case, Justice Venkat clarified that while conventions are not legislated or judicially enforced, their violation is nonetheless a serious breach of constitutional morality, often resulting in severe political repercussions. Several Supreme Court cases have examined constitutional morality in depth. In Indian Young Lawyers Association versus State of Kerala, better known as the Sabrimala case, then Chief Justice Deepak Misra equated public morality in Article 25 with constitutional morality. The interpretation, however, has been questioned and referred to a nine-judge bench for reconsideration. Later in Manoj Narula versus Union of India, The court faced a question about whether individuals facing serious criminal charges could be disqualified from ministerial opposition under the Article 75. The Chief Justice explained that constitutional morality means submission to the Constitution's norms and rejection of arbitrary conduct. Yet the court refused to add qualifications not present in the text. It ruled that the judiciary could only legitimately expect the Prime Minister to avoid appointing such individuals. The rest, it wisely said, must be left to the Prime Minister's discretion, nothing more, nothing less. The principle evolved further in State versus Union of India, State NCT of Delhi versus Union of India, where the court expanded constitutional morality beyond formal adherence. It interpreted it as including liberal governance values, cooperation between state institutions, and ethical duties upon office holders. In Justice K. S. Puthuswamy versus Union of India, the landmark privacy case, the Supreme Court reiterated that constitutional morality required governments to respect the rule of law, obey court orders, and avoid any conduct undermining constitutional authority. From these interpretations, one thing becomes clear: constitutional morality represents the moral compass that guides those in power. Breaches may not always invite a courtroom remedy, but they can still damage the democratic order. Such lapses can be corrected other ways, through debate and accountability in parliament, or ultimately by citizens at the ballot box. The remedy depends on context, shaped by political and ethical responsibility more than legal enforcement. The path forward for India demands that this sense of constitutional morality be continuously nurtured, not just within courts and legislatures, but among citizens at large. It is the living spirit that turns constitutional promises into real justice. It safeguards minority rights, promotes equality, and anchors democracy in ethics rather than expedience. As Dr. Ambedkar cautioned, constitutional morality does not emerge naturally. It must be learned, practiced, and preserved. It is the difference between a constitution that exists merely on paper and one that breathes fairness and dignity into every citizen's life. Only then will democracy in India become not a surface decoration but the fertile core of its civilization.